Hello, everyone. My name is Dillon Graham. I'm a foreclosure defense lawyer in Miami, and thank you for joining us today. Before we dive into any questions, I'd like to make it clear that we're not providing legal advice on any particular matters. We're talking about foreclosure defense in general. If you need guidance on your personal case, please feel free to call us for a personal interview at 305-445-9185, and that's a free consultation. I want to thank our office manager, Amanda, who's here with us today. She's going to be telling me out loud, you and I both, the questions as they are coming in. I would like to tell you, though, a lot of people that come and meet with me, they want to know about the foreclosure process. And I've been a trial lawyer for 33 years, and I started doing foreclosure defense when the crash occurred back in 2008, and the foreclosure filings swelled up as high in Dade County as 5,000 a month, more than 5,000 a month at one time, and there were really no lawyers who knew about foreclosure law or foreclosure defense. In fact, the law of foreclosure has developed dramatically since 2008, and we've been on the cutting edge of this new area of law, and we're very proud that we've been able to help homeowners keep their homes throughout this horrific time in our economy. But what happens in a foreclosure situation is it starts off with the lender filing a lawsuit. First, typically there's a default. Sometimes there's not. We've had people come to us that have been sued improperly. But typically the lawsuit starts out with a complaint. A lot of people call it a lis pendens because when somebody knocks on their door and hands them the paper on top is called the lis pendens. That's not actually what the most important thing that the homeowner is served with at that time. The most important thing is the complaint. And what is it? The two important documents that are attached to the complaint are the note and mortgage. So when we meet with a client, we look at the note, we look at the mortgage, we look at the complaint, and we see if the person that the debt was originally made with is the person that's suing our client. A lot of times, 90% of the times, it's not. The loan has been sold, which gives rise to the defense of standing, which we use often. The plaintiff, whoever the plaintiff happens to be that has filed the complaint, has the burden to prove that they have standing to foreclose on the note and mortgage that our client may have signed years ago. So if the plaintiff can't prove their case on that point, under the law, they should lose. But in any event, first the client gets served with a complaint. They typically have 20 days to file an answer to the complaint. The clients hopefully find an attorney that knows what they're doing and comes in and meets with the attorney, and the attorney will enter an appearance for the client, and the client and the attorney will meet to develop a plan of action to defend the foreclosure lawsuit. So we have an in-depth meeting with the client, find out what their financial circumstances are, how they would like to see the case come out, and then based on our knowledge and experience in the field, we set out to accomplish the client's goals. Another question people ask is, how long does a foreclosure case last? I've seen foreclosure cases that are not defended from start to finish last 4 months. If they are defended, we've defended foreclosure cases for more than 5 years and kept our clients in their home. And the plaintiff is not able to collect any money from them during that period of time. Sometimes people have hardships, and time is very important to them. And so by defending the foreclosure lawsuit, we've been very successful in gaining the time that our clients need to get back on their feet financially, to apply for a loan modification, to obtain the resources to reinstate their mortgage, or perhaps they're interested in doing a short sale. We're able to help the clients with all these situations. Sometimes the clients want to stay in their homes for as long as they can, and so we defend the case with good faith defenses, and then when the case is set for trial, we develop the defenses that we can. If it looks like that we don't have winning defenses, then what we'll do is enter a consent judgment for a 120-day sale date, and try to get the client some cash for keys. We've gotten as much as $12,000 cash for keys. More typically, the amounts you find are $1,000 to $3,000. Another thing we can bargain for, if in the event that we're not able to win the case, is a waiver of a deficiency judgment. Sometimes that's a good thing, sometimes that's a bad thing. If you get a waiver of deficiency judgment, it means they can't pursue an action against you, get a judgment, and garnish your wages. However, if you do get a deficiency waiver, the problem is you'll get a 1099 in the mail at the end of the year, and the difference between what the house sells for and the amount of the loan will be taxable income to you. So those are considerations that you have to deal with. But in any event, at Graham Legal, we have the resources and the training and experience to provide clients with the best legal defense possible, and we're very proud to be able to represent homeowners. Most of our clients have reported to me, I've heard it many times, that the staff is very responsive and understanding, and they appreciate the legal services that we provide to them in the foreclosure situation, which can be very emotional and unsettling time for homeowners and their families. One question is, what should somebody do if they aren't behind on their mortgage payments yet, but might be soon? That is quite a dilemma. I had a client in here yesterday who wanted to do a short sale. A special assessment is coming against the condominium for $52,000. It's a property in Palm Beach County, and they want to sell the condominium and not be liable for that special assessment. So and they're also current on their mortgage payment. So after consulting with us, the client decided that they're going to stop making the mortgage payment and apply for work on a short sale through a realtor and get the lender's approval on that. So we're going to help them through that process. You have to, it's important to realize the consequences of defaulting on your mortgage. There's going to be a hit on the credit. Sometimes there's more than one occupant of a house, their husband and wife, maybe only the husband or the wife signed on the note, so only one person's credit will be affected. That's the good news there, is that one spouse's credit will still remain intact. So those are things to consider. Also, there will be, once you stop making your mortgage payment, it's fairly certain that within 6 months a foreclosure lawsuit will be coming. So that's you have to understand that when you stop making your mortgage payment, that is going to happen. Typically, in order to get relief from the lender, you have to be in default. we find that people that are making their payments, the thinking of the lenders are, if they have a performing loan, they're not going to offer any assistance. So while I do not counsel people to stop making their mortgage payments, I tell them what the pros and cons are, and I let them make their own decision on that point. The next question we have is, should I ever walk away from a property? That's an important question, because there are, when you walk away, it doesn't mean it's over, because it's not. A foreclosure lawsuit is going to ensue, and a final judgment against whoever signed the note is going to be entered, and it's going to affect your credit, and they can garnish your wages, and if you have any other assets, they can be subject to execution on the judgment as well. So I would never recommend that anybody simply walk away from the property. The best thing to do is defend and see if we can come up with defenses to win the case. If we can't win the case, then negotiate a resolution of the matter on the best terms possible for the client. Another question we have is, how long does a foreclosure remain on a person's credit? I've been told, I don't have direct knowledge, I've been told 7 years. However, I think that because of the mass foreclosures that we've had in the United States, lenders aren't going to hold that against you for 7 years. The next question is, can you own a home again after a foreclosure? The answer is yes, particularly if only one spouse signed the note. The other spouse's credit is intact, and they will be able to get refinancing. Also, as I mentioned before, I see Andrew, my nephew, signed in. It's good to hear from you, Andrew. If you have had a foreclosure, I understand that within 5 years you can qualify for a new mortgage. So, but every lender has their own internal policies and procedures. The time frame may be shorter. After you've had a foreclosure, you can rebuild your credit simply by getting credit cards and paying other debt on time. That'll be reflected in your credit report, and you may be able to rebuild your credit rather quickly.
We got another question for you. This person would like to know if how affordable is a foreclosure attorney?
Typically, that's a good question. Typically, lawyers, trial lawyers such as myself, charge $400 to $500 an hour. They ask for a retainer of $5,000 to $10,000. For most people, those type of fees are beyond their reach. So what we've done, because our firm focuses on foreclosure defense as well as some other areas of law, we're able to provide very high quality legal representation at an affordable price. Our standard fee for a foreclosure defense case is an initial payment of $2,000 and $349 a month while we fight the foreclosure. One of the nice things about our agreement is the client is not bound to make the payments for any period of time. You can cancel, ask us to stop representing you, and we'll stop billing you immediately. Also, another thing that I'm proud of is we don't upcharge clients for anything. We don't charge for photocopies. We don't charge for postage. We don't charge for parking down at the courthouse. We don't charge for Federal Express. We don't charge for courier charges. We don't charge for legal research, paralegal time. There's no upcharges. So most of our clients find that our fee structure is affordable and fair under the circumstances.
Another question we have is, are you able to obtain a loan modification after doing a bankruptcy?
Yes, absolutely. I can think of one client in particular. We tried to qualify him for a loan modification, and he had too much debt, and the loan modification was turned down. So what we did is we referred him to a bankruptcy attorney who took him through bankruptcy and wiped out all his debt, except you can't wipe out mortgage debt in Chapter 13 anyway, because he wanted to keep his home. Chapter 7 is you have to give everything up. I have a question here. What's the first thing I should do when I receive a letter from a lender about a foreclosure? My recommendation is that you contact a qualified foreclosure defense lawyer, such as Graham Legal, and develop a plan of action. You'll, in the long run, you'll save money and you'll minimize the impact of the foreclosure on your life. I have another question here. It says, what are some of the alternatives to foreclosure that people can explore? We've talked about that a little bit. There's a short sale is one of the things that you can do, and that's when after the foreclosure lawsuit has been filed against you, we defend the foreclosure lawsuit. You hire a qualified realtor, list the property for sale. If it's the amount owed on the mortgage is more than the house is worth, then we submit, like a loan modification, we submit your paperwork to the lender and get their approval to sell the property to a third party for less than the amount owed. And you need the lender's participation in this because they have to file a satisfaction of mortgage for the new person to purchase the property. That leaves you and the lender in a situation where they have to waive a deficiency judgment against you or not waive it. We've encountered both situations. When I first got involved in foreclosure defense, I thought that when a lender approved a short sale, they automatically waived the deficiency. But I've learned in practice that that's not the case. You get a letter from them approving the short sale, and sometimes they waive a deficiency, sometimes they don't. Another alternative to foreclosure is reinstatement. Let's say that you stop making your payments in February and you just received a summons and complaint. The foreclosure action has been filed against you. You can meet with us. One of the first things we do is contact the lender and get a reinstatement calculation and a payoff calculation. A reinstatement calculation is how much you owe from February to the present. Unfortunately, they add on some fees on top of that. So that's much less, typically much less than the payoff amount. So reinstatement is an option. Payoff, some people are fortunate enough to have other properties or assets or family members who are willing to help them out, to finance the reinstatement or to finance the payoff of the loan. So those are always options. Of course, there's always the option of defending the foreclosure, and as I said before, we've been successful in defending foreclosures for long periods of time. During that time, the client has some breathing room to develop options to qualify for a loan modification, to pursue a short sale or reinstatement or payoff, or bankruptcy is also another option that clients may choose to pursue while the foreclosure action is pending.
What defenses are there for deficiency judgments? People want to know if there's anything they can do about their accounts getting levied.
Yeah, deficiency judgments are a big, are an important concern. In 2008, 2009 through 2014, we saw no deficiency actions being filed whatsoever. I think the lenders were so overwhelmed with all the foreclosure lawsuits, they weren't filing any deficiency judgments. However, since the rate of foreclosure filings has gone down, we've seen the rise of deficiency judgment actions. Interestingly, the Florida legislature enacted a statute recently limiting the time that a lender can file a deficiency judgment action to 1 year. I think that law was enacted in 2014. So that's a great issue. And also in some of these deficiency actions, in the foreclosure action, we have a plaintiff, could be Wells Fargo Bank, Deutsche Bank. And then in the deficiency action, somebody else files a lawsuit for deficiency action. So once again, we have a standing question. Who is this new third party? How did they acquire the rights to bring this deficiency judgment action? So we have the statute of limitations. We have standing arguments. There's also the issue about the amount of the deficiency judgment. The test for that is how much did you owe, as opposed to what the fair market value of the house is. What the house sold for in the foreclosure sale may be $100,000, but the fair market value of the house is maybe $200,000 or $300,000. It's sold low. So the deficiency judgment amount is not the difference. Say you owed $400,000, it's not $300,000. If the house, even though the house only sold for $100,000, if the house is worth $300,000, then the deficiency judgment amount should only be $100,000.
Awesome.
So those are some of the defenses, and as we look over the suit papers in a deficiency judgment action, we may find many other defenses that trial lawyers are trained to look for.
We have a question here from Gina Rodriguez asking if you can own a home after a foreclosure.
Yes, absolutely. Every lender has their own internal criteria for what your credit that you have to qualify for a mortgage loan. I've heard a few years ago that after 5 years out from a foreclosure, you could qualify for a new mortgage, but it could be shorter than that now. Things we find in the foreclosure field, things change all the time, especially if you're married and your spouse has good credit. You may qualify much earlier than 5 years.
Another question from Kanesha Williams. What are homeowners' alternatives for HOA delinquencies?
We deal with homeowners associations called HOAs and condominium associations quite a bit. They have the right to foreclose against owners just as lenders do. The defenses to condominium foreclosures and homeowners association foreclosures are not quite as good as they are to lender foreclosures, because you're dealing one-on-one. There's no change in ownership. However, a lot of these HOAs and condominium associations, they change property managers frequently. There's a change in management, and their bookkeeping system is generally very sloppy. It gets fighting with condominium associations and homeowners associations over the amount due. It can be very cumbersome and time consuming, and we've gone through that process, and we found many errors and have been able to get the amount due reduced, and also we're able to get the condominium association, homeowners association to agree to repayment plans. So we can do that.
Another question from George Lira is, how long does the foreclosure process actually take?
How long the foreclosure process takes varies widely. If you're not represented by an attorney and they serve you right after they file the complaint, they knock on the door and hand you the suit papers, and you don't file an answer or some type of response within 20 days, they'll get a default judgment. Then they'll file a motion for summary judgment, and they could have a judgment within 4 months. You could be out of the house within 6 months. On the other end of the spectrum, if you get a qualified foreclosure defense lawyer involved, we've kept people in their homes after the foreclosure suit has been filed for more than 5 years. So there's a wide range.
Another question from Sophia Perrin. What are some alternatives to foreclosure that people can explore?
Well, the alternatives to foreclosure are bankruptcy, but that's only going to hold off. If you want to keep your house, it's only going to stop the foreclosure for a certain period of time, 4 to 6 months. Other alternatives are reinstatement, find out how much you owe for the payments, the months that you haven't paid, plus the attorney's fees and filing fees that they would charge, other delinquent fees, and reinstate. There's also short sale and payoff, as we discussed before.
We have another question from George Louis Lira. What is the first thing someone should do after receiving a letter from their lender about foreclosure?
I recommend that you contact a qualified foreclosure defense lawyer like Graham Legal and come and meet with us. We consult with people, and there's no charge, and we can develop a plan of action based on your personal circumstances to decide how best to meet the challenge of a forthcoming foreclosure action.
We have another question from Sophia Perrin. How long do people have to vacate their homes after a foreclosure?
That's a question that we get often, and it's nothing like a landlord-tenant situation. In order for the lender to force you out of your house, they have to go all the way from filing a foreclosure lawsuit to getting a final judgment, but that you still don't have to leave when they get a final judgment. Then they have to set a sale. Typically, it's 30 days after the judgment date. We can get it. We've been able to get sale dates put off for as long as 180 days. And then if we're working on a loan modification, we had one client where we got the sale canceled 6 times. And we kept him in the property for maybe 2 years after or more after a judgment was entered. And so after the property is, after there's a sale, you still don't have to leave the property. Next, typically the lender is the successful bidder at the foreclosure sale, and they sit on their hands for quite a while before filing a motion for writ of possession. So until a writ of possession is served on you by the sheriff's office, you don't have to leave the house. If a third-party bidder buys the house at the foreclosure sale, typically they're in more of a hurry to get a hold of the property because they're probably an investor and they want to fix the place up and get it resold.
This individual would like to know, what are the options for someone who does not want to keep their home but wants to minimize the damage the foreclosure may cause?
Right, we have a lot of clients that fit into that category. The house is like an albatross tied around their neck, and they want to get rid of it. That presents its own set of problems, and we're very good at helping clients get themselves untangled from a property and an expense and a liability that they no longer want. One of the things we can do is to work with them and the lender to do a short sale, and there's also before suit, lenders do a deed in lieu. That's very unusual. Typically, the clients that come to us, they're already in suit, and they don't do a deed in lieu. You do a consent judgment, and you work things out with the lender that way.
Another question from Jenny Figueroa. Is it possible to change attorneys if you already have representation?
Yes, you can terminate the services of a lawyer at any time if you're not satisfied with them. We have many clients who have come to us who are not happy with their representation. We prepare a letter for the client to sign and send it to the old attorney, telling them that they've retained Graham Legal and they should not contact the client any further. And then we send them a stipulation for substitution of counsel. They sign it. We send it to the court. An order is entered substituting the new attorney.
What happens if you purchase a foreclosure property at a HOA auction and there's still a mortgage?
We've had a lot of clients in that situation. When you buy a property, you buy it as is. If you buy a property at a foreclosure sale and it's a homeowners association foreclosure or a condominium association foreclosure, you take it subject to the first mortgage. And also if there's any property taxes due, you take it subject to that as well. And then we're in a situation where we enter an appearance in the foreclosure action if there's a lender foreclosure action, and we defend the rights of the person who purchased the property at the homeowner's sale or the condominium association sale. We've done that successfully many times. I think that's about all the time we have. I hope that the information we've offered you has been helpful. We're excited about doing the Facebook Live meetings with clients, and we look forward to doing it more in the future. Other areas that we would like to talk to people about is personal injury, contract disputes, and other areas related to consumer protection. So go to Graham Legal's website, www.grahamlegalpa.com, and you can see the practice areas that we work in. And on our blog, you can leave comments, or on our Facebook page, you can leave comments on other areas of law that you might like us to talk about. If you would like to meet with us, you can call Graham Legal at 305-445-9185 and schedule a free consultation. We look forward to talking to you soon. Take care. Bye.